Welcome to the Generous Benefits Podcast, where we help employers create meaningful people-first benefits that make a real impact. I'm your host, Amanda Brummitt. We're joined today by Lori Oliphant, managing member of Steptoe & Johnson's Dallas office and a nationally recognized employee benefits and ERISA attorney. Lori advises employers across industries, from Fortune 500s to nonprofits, on the design, administration, and governance of retirement and health plans. She regularly represents people before the IRS, Employee Benefits Security Administration, and Pension Benefit Guaranty Corporation. Today, we're digging into the top compliance missteps that trip employers up. So if you don't want to be on the radar of the Department of Labor, tune in to hear what Lori has to share. Well, Lori, thank you so much for being here with us today. And Brett as well. I asked Brett to join in case we need to have any conversations about, do brokers really ask this? And so he's our resident broker. So Lori, let's start with, who are you?
Well, I'm Lori Oliphant. I'm an employee benefits attorney. I've been practicing in this area for well over 20 years. So I've seen a lot of things. I haven't seen everything, but I've seen a lot. I'm currently working at Steptoe & Johnson, and I'm a member there and the managing member of the Dallas office.
Awesome. And then, Lori, let's start with plan documents. Why are they important both for retirement and health?
Yeah, so I think from a basic standpoint, they're required by law. So as you may know, employer-sponsored plans are subject to the Employee Retirement Income Security Act, what we often call ERISA. And then they're also subject to the Internal Revenue Code. Now, under ERISA, you're required to have your benefit plans written, described in a plan document. And the purpose, of course, is to make sure everybody understands what is going on. What are the promises? What is everybody's responsibilities? What are the conditions and limitations? And so that way everybody kind of understands what will happen and what won't happen. And that it's kind of intended to be protective of the participants in that manner. Mm-hmm. So under ERISA, we have to have plan documents. Also, under the code, there's several different qualification sections that often reference the plan document shall say or something. So it implies that there will be a plan document there as well.
Okay. And then, at least in our line of work, I find that most people don't care about having those things in place day to day. But what happens if they get audited? What happens if they decide to sell their company? Do you then see people scrambling for these?
Yeah, I think it becomes a big problem. I mean, I know it's one of those things that, everyone's running their business. It's kind of like it's in the back of everyone's minds. Even with an HR department, there's a lot of other things going on other than, running the plans. And even in that sense, most of the people are running the plans. They're not worried about the formalities. They know how it's working. Everyone knows how it's working. So what does it matter? But it does matter because there's several times when it's going to come up and you're going to feel like scrambling to get those documents, right? Obviously, a participant is allowed to request those documents. So under ERISA, you have to give them those documents within 30 days. So if you don't have them and you have to run around and try to get them drafted or call your broker and get the insurance policies and things like that, it could take quite a while. And if you don't give them to them in 30 days, you can have penalties imposed, $100 a day. And so the second big thing that often happens is, you get a call or a letter from the DOL, the Department of Labor, or the Internal Revenue Service. Generally, the Department of Labor would send a letter saying, hey, we have a question about your plan. Can you go ahead and send us all these documents? And the very first thing on that letter is going to say the plan document. And so if you don't have it, you might be scrambling again to get it together to, send to the Department of Labor. But a big thing that happens too is if you're in a company that is possibly looking at selling, to a third party down the road, there's what we call due diligence in those transactions. And so the other side is going to request all of this documentation. And to the extent you can't provide it, it causes a concern to their side that there might be some risks, not only in the fact that you don't have the documents, but it kind of gives a perception that you might not have other things in line either. So you want to make sure that all these ducks are in a row so that you can present yourself the best way possible to that buyer.
Definitely. And then more from a fiduciary responsibility perspective, whose job is it? Is it the employer's? Is it the broker? Is it the payroll company? Is it the person that's running the retirement plan?
So as a general matter under ERISA, the plan fiduciary is responsible for administering the plan.
Mhm.
Now, the plan sponsor, which is the company,
Mhm.
is responsible for adopting the plan. So, in a general sense, the plan sponsor is required to actually adopt the plan. That might be through a board resolution, signing the actual document, and then it's put in the file. And then the plan administrator would actually follow the instructions. How is the plan going to be operated? I find that in some smaller companies that those tend to be the same person, right?
Right.
So you would tend to see like the board, it might say the company is the plan sponsor and the plan administrator. Well, what does that mean? Well, sometimes it means the board of directors or the board of managers of that company. So what happens is you are wearing what we call two hats.
Mhm.
In a plan sponsor role, you're not subject to the fiduciary responsibility rules of ERISA. So you can adopt a plan, amend a plan, terminate a plan without regard to the interests of your participants and their beneficiaries. Whereas a plan administrator has to put on their little fiduciary hat and has to say, hey, if I do this, am I hurting my participants and beneficiaries? Am I violating my fiduciary responsibilities of ERISA? So sometimes, especially some of my smaller clients, we try to differentiate those roles just so so you're not conflicted completely, as to what's going on. But you are permitted to sit in both of those roles. So I don't want to say that you can't do that. But if you have the capability of having other people be in the fiduciary role versus the plan sponsor role, we often prefer that just to kind of differentiate those roles. But again, in a smaller company, that sometimes is not the case.
Yeah, that totally makes sense. And then, Lori, another area I've heard you talk about where employers really get tripped up is in making decisions around claims procedures. What are the things that they need to be really careful about there?
Yeah, and I think this most often happens in self-insured plans. We have in the medical world, usually it's the health plan, right? Like a lot of the other ancillary programs, like your dental, vision, those are usually fully insured, and they're going to be taken care of by the insurance company. Similarly, if you have a fully insured medical plan, those claims are actually being processed by the insurance company. But if you have a self-insured or a self-funded plan, medical plan, sometimes you are often involved in maybe the appeal. You might be involved in the initial claim itself, but usually I find that we're involved in the appeal. So maybe let's say if you have, your third party administrator, whoever it is usually another type of insurance company, but they're not your insurer. They're just acting as the administrator of your plan. And they go ahead and they, look at the document and they say, okay, this is denied. Well, then the individual has the option to seek an appeal of that denial within certain timeframes that are prescribed by ERISA. And then that appeal normally will go to the employer or to the plan administrator of the company sponsoring the plan. And so then you're in the situation of being like, well, do we want to follow what the TPA said, or do we want to overturn it?
Yeah.
And so you got to be very careful about whether or not you overturn the decision of the TPA, especially if what the TPA said appears to be what is in the plan document. If you start making exceptions, you can start implicating your fiduciary responsibilities under the plan. And one, you have to treat all your participants and similarly situated participants the same, right? So if you make an exception for one person who has a certain kind of condition, you need to make sure that you're being consistent in that decision making. So often I tell my clients, hey, if you're going to make exceptions, if you're involved in claims procedures, make sure the minutes of that meeting indicate what the decision was, why it was made, down to the integral detail, because that detail may be the very reason that differentiates that decision down the line with respect to a different participant. And you don't want to be ambiguous with those decisions because, of course, if oftentimes what happens is we'll make a decision that might be beneficial to one of our owners that's not so beneficial to one of, our lay persons.
Mhm.
And so it may not be considered fair, and that could be a breach of fiduciary duty. The other thing that often comes up, though, in self-insured plans, again, a self-insured plan is the type of plan where you're paying the benefits out of the general assets of the company. but very few, especially smaller employers, fully pay 100% of the claims outside, from their general assets. Rather, they kind of set a limit, what I'm going to take the first million, the first 2 million, whatever it is. And then they have a stop loss insurance policy where an insurance company comes in and says, okay, employer, anything you have over the 1 million, we'll reimburse you. We'll pay you, the employer, for anything you pay over the million. So we're kind of protecting ourselves, protecting our business for those catastrophic claims. Well, if you make the only reason that stop loss insurance policy is issued to you is because they understand what the terms of the plan are. Mm-hmm. And so if you start changing by exception what the terms of that plan are, that stop loss insurer may deny your claim. Mm-hmm. So now all of a sudden you have, overturned the TPA's decision. You've decided to pay this claim. It ends up being a $3 million claim. And the stop loss insurer says, no, the plan says we weren't going to cover that. Ooh. That's on you.
Oh, yikes.
Yeah. Yeah.
And do you find these are usually exceptions that they're coming from a good place, but it's just not wise across the plan? Or
yeah, they kind of split. They kind of split. Sometimes it's there's mistakes or there's oftentimes there's the thing where maybe the plan wasn't as gracious as it could have been as far as things that we give to coverage that we give to newborns. Mm-hmm. Okay. And so everyone always has a, sweet spot for, how are we going to protect the babies? So they want to make an exception and they're like, well, can't we cover this? Yes, you can cover it. So, it's often it has nothing to do with whether it's, a highly compensated person or not. Sometimes that just comes in from just everybody, those types of claims. And in those situations, I say, okay, what I would do is make sure that, you make that change, call your stop loss insurer and say, hey, we'd like to make this change. And if they say that's going to be a change to your premium or not, but it's better to have it up front so everybody knows what's going on. However, I will say the other is that oftentimes it comes from the highly compensated people. So they are, they feel like, hey, I've done everything I can for this company. I feel like I'm almost owed, better coverage. And so they ask the question. And I get why they're asking the question. I get that there's a need for wanting the best coverage that's out there, but it's often misunderstood that we're kind of confined to the terms of the plan. And so again, if it's asked by a highly compensated individual and we want to make the exception, I think we just need to be prepared to make the exception for everybody.
Yeah, consistency matters. Brett, you've never run into this ever, right?
No. And there's so many strange things we run into. I know you're going to ask a little bit about eligibility, but becomes the over and overarching, the most common thing you get is an email or a phone call is that, hey, I just hired Jim Bob to be our new head of whatever. And I told him his insurance would start on October 1st. And I'm like, when did you hire him? Because the plan says he doesn't start till December 1st. So this is a nice pickle we're in now. Thanks, buddy.
Well, let's go ahead and let's jump to eligibility. That's a great segue to it. So, Lori, explain eligibility first, and then let's talk about the risks if we're too loose on letting Jim Bob be on the plan.
Yeah. And so again, I think that's it comes up a lot. As Brett was saying, it comes up a lot, especially in smaller companies. They tend to have family owners and, or they're trying to get, unique talent and they make promises during the negotiation that they don't recognize will actually implicate the administration of the plan. And so, we have what we refer to as non-discrimination requirements that are applicable to self-insured plans. They're not currently applicable to fully insured plans. So what does that mean? That means that we can't provide more advantageous eligibility terms to highly compensated employees and their dependents than we do for non-highly compensated employees. And so when we make exceptions for, hey, I want to get my, I'm going to put my wife on, you can put her on as a spouse, but I'm going to put my 30-year-old daughter on, like I'm going to do these things. I'm going to get my mother's on, and all these people are not employees and they wouldn't necessarily be covered as dependents under the plan. And so what are we doing there? Oh, well, I'm going to put them on. I'm going to list them as an employee. This makes me nervous.
Yeah.
This makes me nervous for two reasons. I mean, if we have a fully insured plan, and Brett, I'd love to hear your side of this story too, because every once in a while someone will be like, well, no, my broker told me that all I have to do is tell the insurance company who my employees are. They don't check. And I was like, well, that might be okay on day one, but if you're person who's not actually providing services to you and has never provided services, they're not like on a leave of absence, a bona fide leave of absence. And then all of a sudden they have some catastrophic medical expense. There's a possibility the insurance company is going to call and ask about that employee. So it concerns me that you're putting yourself in a situation that may not turn out the way you want it to turn out. Do you ever come up with that, Brett?
Yeah. I mean, it's the conversation, and back to, it is true in some stances, they don't ask you to prove up who your people are. And then in other situations, like they're double checking tax rosters and payroll documents too. So like the different rules of engagement that someone is trained is a checkpoint. Like they see one all the time. They don't see we might want to research this as now we're getting close to, $75,000, $80,000, $100,000 paid out for those. And I'm like, there better be documentation and proof somewhere in that. I mean, the ones that I've always run into that feel like maybe some way, somehow, but it's super murky, like board of directors that are working in a company, but maybe not full time when those requests come in. That's a weird one that gets put in. That's a little murkier than just the aunt or the adult child that's not really working for the company, but actually is drawing payroll. Those become more common and not so murky as the ones that have a legitimate reason, but don't have a good financial documentation trail.
If they're on payroll, like really on payroll, even if they're not doing anything, is that better?
I mean, I think it gives you something, but it doesn't.
I mean, we also have the actively at work issue. I mean, I had one where it was actually simply a transition from a PEO, unbundling a PEO to just in-house insurance for a company on a fully insured product. But the person was on leave on the PEO on disability, or they're just on leave, maybe an FMLA or something. And their death occurred after a transition. So they had never actively worked at the company because their active working was in the prior calendar year prior to transition on the PEO for that one. That got to be a real murky situation that was like, no one's thinking about that definition of are we looking at claims afterwards from actively working and now we don't have, a single day worked under company on new contract.
Right.
Right. Those become the no one's doing anything malicious. It's just normal process of business of changing PEO to employer plan.
Yeah. So, so there's so many other things that come up on the eligibility side. Again, focusing on the medical plan side right here. So we talked about fully insured plans, but self-insured plans, again, we have those non-discrimination rules. And so if you're letting people on, for a highly compensated person's benefit, for example, that starts to implicate those rules, and that could result in taxable benefits to the highly compensated employee. We don't want that either. I think a big concern that often gets overlooked is what we call a multiple employer welfare arrangement. So when you have a plan that covers employees or individuals that are not part of your employer group, your controlled group, you have what's called a multiple employer welfare arrangement, or what we like to say, MIWA. And so what that means is like under ERISA, as a general matter, a self-insured plan is not subject to state insurance laws. So, if you have a self-insured plan, you're not required to satisfy those insurance laws that say, hey, I'm an insurance company, or you're not required to satisfy the laws that say, hey, every insurance policy that's issued under this state or issued by this state is going to cover X, Y, and Z types of benefits. You can actually control how your plan is run for the most part, subject to ERISA. If you have a self-insured MIWA, you implicate a lot of different state laws, including those state insurance codes on what kind of benefits you're going to provide. And you also implicate the state insurance laws. So you become an insurance company, effectively. You can be required to, have reserves and do filings and all these things. So self-insured MIWAs are the no. So you can still have a MIWA as a fully insured plan, but they're less problematic in most. You have to again look at the state law, but less problematic in the sense that a lot of state insurance codes will say, okay, if you're fully insured, you're not going to be subject to the state insurance code requirements for, reserves and filings and things like that, because we know you have an insurance policy that was issued by this state that already complies. And so we're going to essentially say you're compliant. But you do have additional filing requirements as a MIWA. There's a new little, or it's not new, it's probably been there 5-10 years by now, but the Form 5500, it's probably at the very end of that first part where it says, are you a MIWA? So you would check it. And so there's two little questions there about being a MIWA. And then there's a Form M1 filing requirement that also gets implicated by a MIWA.
Skipping right back over a loaded term back that you had in there, your controlled groups, controlled entities. Do you have an easy way to explain that? Because every time I look at it, there's some easy ones, and then there's a whole litany of tests from what looks to me like pension plan type stuff that goes how to define it, and that becomes one of the craziest org charts of if and then what, maybe not, but maybe, and then get legal advice, and lawyers don't always agree how to define it. So,
yeah, I would say this is a question that comes to me. I would say weekly. And some of them are easy and some of them are very difficult to deal with because it is complicated. But here's the thing. You have what in the code and a little bit more on the ERISA side, but mostly in the code, we look at whether or not you are part of an employer group and whether you're treated as a single employer with another entity. So you're treated as a single employer with another entity if you are a control group or an affiliated service group. Now, control group is a little bit easier to handle because it's nothing more than mathematical calculations, right? We're looking at whether or not you are related to another entity effectively by an 80% control test. That's a little bit different than, you might look at a consolidated return at a 50% level, and some other accountants look at things at a 50% level. So we have to be very careful when we're talking to our clients to say, okay, this is an 80% control. And so, you have a parent subsidiary. A lot of parent subsidiary groups are 100% owned. That's clearly a control group. And then if they have another subsidiary below, 100% control group. If that subsidiary is 80% control group, 70% is not a control group. That's the easiest one, parent subsidiary. Then you have brother sister groups. This is a little bit more difficult, but again, you got to get past the 80%. And that is when there's 5 or fewer persons that own 80% or more of 2 entities. This gets implicated a lot by husbands and wives, family members, and, and just friends that like to be investors in a lot of the same companies. And so, so you might have I own this company and I own that company and my daughter owns that company. But then you have to see whether or not do you guys own 80% of both companies? Looking at everybody's aggregate is 80%. Yes. Then there's a second part of that test that says, okay, but do you have the exact amount of interest in each of those entities that equals at least 50%? That's a little bit more difficult to look at. But again, we start with 80%. If we don't get past that 80% threshold, we're not in the control group. The affiliated service group is where it gets real messy. Because that's a fact that, yeah.
I hate this rule.
And this is totally facts and circumstances. We have very little guidance. There were proposed regulations in the 1980s that were withdrawn. Effectively, we have like an IRS, audit guideline that says like stuff that was in those old proposed regs. So you really don't know. The IRS used to give determination letters as to whether or not you were an affiliated service group, and they don't do that anymore. So you're really kind of, you're just running the risk. It's like you just might be running the risk. And so an affiliated service group is much more difficult. There are 3 types of affiliated service groups, but the reality of these groups are you guys working so closely together that you're effectively related? Like the big, for example, like law firms or medical associations, a lot of times you'll have like a professional association with a lawyer or a doctor, and then they own 2% of the medical practice or the law firm. And someone would be like, oh, we're not a control group. And I would say that's true. You're not a control group. You only own 2% of the law firm, but you are an affiliated service group. And that is because you own you own some percentage in another entity that you worked with purposefully to provide services to a third party. That's an affiliated service group. So a lot of times, one of the things that comes up that you can almost automatically say that we're going to have a control group, like I need to talk to you about this, is when people say, okay, well, we're going to put all of our management people in this entity, and we're going to give them a health plan, and we're going to put everybody else in this other entity, and we're going to give them a health plan. Yeah. Unless those plans are fully insured, we're probably going to be implicating the non-discrimination rules. And then you also have, don't forget that silly little cafeteria plan out there that we allow people to make their pre-tax premium payments in. That has its own non-discrimination rules.
Lori, you've mentioned non-discrimination a couple times this morning. Can you define it and why it matters?
Yeah. And so I know we've been focused a lot on health and welfare, but this is kind of one of those concepts. And similarly, control groups, it's the same thing, where it's a concept that is over retirement plans and the health plans, and the concept is the same, and that is that as a ballpark. Sometimes it can be lower if you satisfy some other tests. Obviously, higher is great too. So once you get in the plan and you get past that coverage non-discrimination discussion, then we look at the benefits that are in the plan, right? And so if we pass coverage and everybody's in, and then all of a sudden we say, you know what, for the retirement plan, for example, we're going to give our highly compensated people a 6% profit sharing contribution, and we're going to give our non-highly compensated people 3%. As a general matter, that's not going to fly.
Yeah.
So a lot of times what you end up doing is you have to satisfy other certain types of tests, and they get very complicated, but there are other certain types of tests where we can differentiate those contributions and still pass that non-discrimination test, but it requires a minimum contribution being made to those to the non-highly compensated people, and then certain tests being satisfied for the highly compensated individuals. So if you don't satisfy those requirements, you effectively lose whatever the tax advantage is. So in a retirement plan, the plan would become disqualified. That means all the benefits would become taxable. In a health insurance plan, a self-insured plan, that means all the benefits to those highly compensated individuals would be taxable. Not their premiums, their benefits. So like the $100,000 procedure they just got.
Wow. That is wild. And Lori, so I've been in that, like, I understand that people are trying to be competitive and they're using it as a, recruitment and retention tool, but I would have to imagine that it doesn't play out well in public opinion or in front of some governing body when you've got people making large amounts of money and people not.
Yeah. I mean, I think that's the thing, is like everyone, I think people are they're like just trying to get the right talent and trying to do what's right for their business. And I don't think it's intended to be like, oh, I purposely am not trying to give this benefit to XYZ. I think it's about like enticing this person to come and stay at your company. So they're, it's not ill intent at the beginning, but that's not the concern of the government regulator, right? The government regulator from an ERISA, like the Department of Labor, the whole purpose of ERISA is to protect participants and beneficiaries. So if you're not doing something in accordance with ERISA, it doesn't matter that there was a good intent for somebody. It's that you didn't follow the rules with regards to the entire plan. On the Internal Revenue Service side, or the tax code side, the IRS is going to look at you and say, well, this is costing us money. Yeah. We're giving you this, this is a tax issue for us. This is a revenue raiser. And so we are foregoing that revenue because you're telling us, you promised us that you're going to give these benefits to enough people and you didn't. And so I can't, from their perspective, they're like, well, you just lost the tax qualification. That's where it is.
Do the gross up benefits, the fringe benefits we typically see in a lifestyle spending accounts or executive MERP plans, those don't fall under the same non-discrimination regulations, do they? Or do they?
Well, some fringe benefit plans do have some non-discrimination rules. Not all of them. I want to say an educational assistance plan has a non-discrimination rule, right? I believe an adoption assistance plan would have a non-discrimination rule, but certain, worker condition fringe benefits and things like that, you don't have to give those to everybody. So you can certainly put those, in available for everybody else. Now, I think what you were referring to also is these executive physical programs. Those are specifically accepted out of non-discrimination, but they have to be for those very specific reasons that are allowed under the regulations. It's not to provide actual care. It's really that diagnosis. And so it's a very specific thing that allows executives to get certain executive physicals and things like that without implicating those non-discrimination requirements.
Okay. Well, and I'm going to hijack for a second. I want to go back and revert all the way very back to the beginning now that I have a microphone. When it comes back to the whole foundation of this, of the plan documents, we also see, these very basic, bare minimum, just barely meets the requirement document generation compliance tools out there to create a wrap plan or a mega wrap plan to comply with all of your ERISA requirements and blah, 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 that is so non-specific, it doesn't tell anybody anything.
Right.
But yet the plans have to all be administered on actual plan documents. So when both exist at the same time, how do you what's actually compliant when you have true documents and the get out of jail free documents?
Well, I think works until it doesn't work, right? It's I think you could have a document. Well, and here's the thing: I'm not sure if you have a situation where there's floating documents and they don't all coordinate, and you kind of think you're doing things right, but you may not be doing them right. It's only going to take one disgruntled participant and possibly their attorney to call you and be like, "Can you please send me all those plan documents?" And they're going to find that they're not consistent.
Yeah, right. This is where most of it starts, is the unhappy employee.
Right. And so I think in a lot of cases, you'll and here's the other thing. I think in good faith, there's a lot of, HR departments that say, hey, I have plan documents. I can't tell you how many times I ask clients for all their plan documents and they send me things and I'm thinking, these don't even say the same thing. These aren't even finished. And so if I can see that, the buyer is going to see that, the Department of Labor is going to see that, the plaintiff's attorney is going to see that. And so it doesn't put you in a good spot to defend yourself, right? So if you want to be in the most protective spot, it behooves the client to just constantly let's see what this says. And what else is happening that's consistent with this? The wrap plan document is an interesting concept because, as you said, so the wrap plan is this kind of I consider it like an umbrella, right? It's out there to be okay, here's my basket of all my welfare plan programs. And I'm going to put all these ERISA compliant things in here because it's possible that the insurance policies that I give you don't say what they need to say for ERISA. And so I have all of it here. But there's also the possibility that some of the things you have in this wrap plan are not consistent with that insurance policy. But yet the insurer is going to administer that policy in accordance with the policy, not your wrap plan. So you have to be careful to I would say in the wrap plan, this provision applies if there is no other existing provision or the provision in the insurance policy does not comply with ERISA. Boop, this one applies. It's so like we have this. And then, but it's still to like look at the claims procedures in the insurance policy to make sure they're compliant, even if they're a little bit different than the ones you have in your wrap plan. Because it's a question for the insurance company, like, hey, you have to do these new things under disability claims procedures, right? Like maybe they haven't been updated yet. For a long time, I mean, this was years ago, but there was an insurance company that I worked with several times, and they refused to put in ERISA claims procedures in the policy. And I was like, you do know you're selling to employers who are subject to ERISA, right? And yeah, but this policy was approved by the state insurance commissioner, and so we're not going to do it. Now, that's not the case anymore. It's completely been updated and it's fine, but I thought, this is odd. So
what a strange stance to take, right?
Yeah. And so we would take their policy and we would put an addendum on the policy with the claims procedures. And we were like, these are how you have to actually do it, because we have a disclosure requirement under ERISA to give everybody a summary plan description with the claims procedures that comply with ERISA. So here we are trying to give our disclosure of what's going on. And so there can be some conflict, but that's not a good way to administer the plans, because like I said, it's a hole that somebody's going to grab onto when they have the opportunity.
And I've always felt like it's probably best practice just to have all of your ducks in a row, and then you don't need one of those documents.
Yeah.
Is that pretty
I think the wrap plan, I mean, a lot of times the wrap plan is there really for the Form 5500. So, as a general matter, you're going to file an annual report. And again, this is probably for larger companies. You have to file an annual report for your welfare plans if you have more than 100 participants. So it's like, well, okay, I don't want to file a 5500 for my medical and my dental and my vision. Like that'd be 10 different, And so they all decided, okay, well, we're going to file one because it's a single plan. And in order to evidence this single plan for Form 5500 purposes, people, started saying, okay, we have this wrap plan document. And so it's not necessary. I don't think it's a requirement in order to get a single 5500 to get there, but it's certainly helpful to say, oh yeah, it's a single plan and this is what we do. And this is why we can file this one single Form 5500. But the other thing that the wrap plan does is it does give you a way to kind of close the loop for some non-compliant provisions that might be in the other provider's documents. Again, like, hey, DOL, we told them what these are the claims procedures. And this is what we were trying to do.
And trying helps, right? If it looks like you're trying to do the right thing,
I think it's a better conversation.
I mean, it is the over and over again conversation of like, well, we haven't started at step 1 and we want to start on step 20. We need to do the first 20 simple things first is the general conversation when I get pulled into these things.
Right.
Well, Lori, you've been a wealth of knowledge, and I feel like we could have like 27 shows with you and not even cover everything. But is there any last pearls of wisdom that you would share with employers that are trying to save money, but trying to also do right by their employees?
Yeah, I think if you could just set apart some time, annually to just kind of take a little checkup on your documents, keep notes during the year of things that maybe kind of didn't go the way you wanted, and get those in the plan documents for the following year. Don't just administer it how you want it to be done. Actually take that formal action to get it done. I would say also, these days, making sure somebody actually is monitoring not just your retirement plans, but your health plans. Be that fiduciary, be the active fiduciary. Ask the questions of your broker, of your consultant, whoever else is involved with your plan. Because those are the things that I say, like if a Department of Labor is going to audit you, having emails where you asked the question or pushed back on something, that to me is evidence that we were trying to do what we could do. I mean, there's a lot of things that are out there now that are not really in the employer's control. And yet it's the employer's responsibility and the employer's liability. And so all I tell my clients at this point is ask the question in an email and get the response in an email, because that's all we can do.
Yeah. most definitely. And I want to remind everybody that they can also call their attorney and you can tell them the truth, the whole truth, and nothing but the truth. And it likely won't be used against you.
Yeah, no, it'd be like, okay, I mean, I was talking to someone yesterday and she started saying something. I was like, no, did you just say? She's like, I didn't tell you that before. And I was like, okay, well, let's think about that. Let's think about how we could position that circumstance to be compliant or to have a good position if the IRS or the DOL were to come knocking on our door. I'm not here, I've tried very hard in my career not to be a no person. Like I do try very hard to get us where we can go, but there's some things that, you're strapped.
Yeah. Well, Lori, thank you so much for your time and your knowledge, and we just really appreciate you.
Yes. Thank you so much for having me.
Lori, thank you so much for making compliance feel less like a maze and more like a plan. If you're listening and thinking, okay, we've got some housekeeping to do, you are not alone. Gather those plan documents, be consistent with claims, conduct your non-discrimination testing, and keep an eye on eligibility. As always, today's conversation is for education, not legal advice. If you need counsel, connect with a qualified attorney. And remember, if it sounds too good to be true, it probably is. There are smart, defensible ways to control costs and deliver better benefits, but the real ones don't come from handshake deals or murky arrangements. Thanks for listening. We'll see you next time.